Butler County, Kansas, case entitled State of Kansas versus Jared Gillum. It's case number 2024 CR 477. Jared Gillum appears from apparently Hutchinson Correctional Facility's Zoom location. Joseph Favre appears as defense counsel. Amber Norris on behalf of the state of Kansas. This matter comes before the court at this time for sentencing. The court's docket notes indicate that Mr. Gillum appeared before this court on April the 11th. He pled guilty at that time to making false information, a level 8 felony in count 1, and misdemeanor theft, a class A misdemeanor. A pre-sentence report was ordered. Sentencing originally set for May 27th. However, May 27th notes indicate that the pre-sentence report was not completed yet, and the matter was continued to today. Court does have a completed pre-sentence investigation report compiled by Lori McManus, pre-sentence investigator. She is not present on the meeting. However, Tony Bauer from the Court Services Office is on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated therein?
No, Your Honor.
Any objection by the defense, Mr. Favre?
No, Your Honor.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to the primary count in this case is criminal history score C, and the court will proceed further accordingly. Ms. Norris, do you know of any legal reason why sentencing should not be completed in this case here today?
I do not, Your Honor.
Mr. Favre, are you aware of any such legal reason?
I'm not, Your Honor.
Mr. Gillum, are you aware of a legal reason or any other good reason why the court shouldn't proceed with sentencing here today?
No, sir, Your Honor.
The court will proceed further then. Counsel, I am aware that there's been a motion for a departure sentence filed in this case. Court became aware of that this morning. It is entitled Request for Durational Departure Findings, filed by Mr. Favre, apparently on behalf of his client. I have an unfiled copy. Mr. Favre, has this been submitted for filing to the clerk's office?
It has been submitted, and a copy was also sent to the county attorney's office.
And you are aware of it and its contents, Ms. Norris?
Yes, Your Honor, I received it this morning.
You may proceed further in regards to that motion at this time, Mr. Favre.
Thank you, Your Honor. So essentially, Mr. Gillum's in a little bit of a different position from your standard defendant. He is presumptive probation. However, he does have a special rule application that is a discretionary application that, if the court were to impose it, could allow his presumption to be flipped to presumptive prison. In discussing this case with Ms. Norris, it felt practical to ask the court to impose that discretionary special rule, given that Mr. Gillum is currently in custody at Hutchinson Correctional Facility on a separate case until at the earliest April 3rd of next year. We discussed the idea that instead of perhaps asking the court to not impose the discretionary presumption, which is normally what we would ask, and normally what would be the basis of a plea agreement, that instead we would factor in the fact that he's in custody and ask the court to consider granting, imposing that discretionary special rule and then granting a departure of the mid-box number by 5 months to 13 months, which is what the state agreed to. I'll note for the court that we think this will extend Mr. Gillum's sentence a little bit, but maybe not extend it a full 13 months. Mr. Gillum has accepted early responsibility, as the durational departure notes for this case. He hasn't really ran from it, and we think that there is substantial and compelling reasons to support defendants who take responsibility early, as well as defendants who enter plea agreements in good faith with the county attorney's office, to have their cases expedited and handled in an agreeable manner with both parties.
So this sentence that you envision, would it also include concurrent sentencing with his current prison sentence?
So, Judge, this case is not required to run consecutive to the case he's currently doing his time on. It is required to run consecutive to a different case. That case is currently post-termination, and I think that case has already expired. The case he's doing time on is Sedgwick County Case 23 CR 2175, and that case actually occurred after this case, and so it's not required to run consecutive to our case. So we're asking the court to just follow the mandatory special rule consecutive that is noted in the PSI, which is to the 19 case, but not order this case consecutive to any other cases, as it's not required by law. And as Mr. Gillum is agreeing to do whatever time he's given in custody, in the first place. So. And I would also note for the court that Mr. Gillum is currently taking good advantage of his time in DOC. He's involved in programs. He's doing the best he can to try to make the best use of his time in DOC as well.
So he's going to get out on his current case, or at least he's eligible to get out in April of 2026, correct?
That is correct, Judge. And this case should extend that early release date by a little bit. It will depend on his good time credit and other factors, but this case 13 months from today is obviously longer than April, so it should extend his out date. We just don't know exactly how long that will be. And Mr. Gillum is aware of that.
Glad Mr. Gillum made it back.
Yeah, my camera got messed up. I was trying to find the CO to come and fix it. I'm sorry.
All right, I can see you just fine. I can hear you just fine. So we're in good shape right now, Mr. Gillum.
All right, thank you. I apologize, sir.
Just trying to wrap my head around this, Mr. Favre. A concurrent sentence with 20% good time credit, he may not have his time extended at all. If so, very, very little.
It's tough to say exactly how much it will be. We think it'll be some, but we don't know the exact amount. And he's going to end up doing a chunk of time anyway. And so we thought that it was appropriate since he was already doing a chunk of time.
What's the state's position on this?
Your Honor, we did discuss it based on the fact that this was a 2021 case and that the case he's in on is a 2023 case. We did basically discuss the possibility of, depending on where he fell, agreeing to take, somewhere between 3 and 5 months off of his sentence if he was going to basically request that the court invoke the discretionary special rule and order him to DOC based on the special rule, which I would concur with Mr. Favre that this case must be consecutive to has appears to have been flattened, and according to his Casper is noted as inactive.
All right, very well. Anything further, Mr. Favre?
Not at this time, Your Honor.
All right. Move forward then. Are there any victims and members of a victim's family present who desires to address the court in relation to the Gillum sentencing? Court finds no such persons present. At this time, I will ask for formal recommendations from counsel regarding an appropriate sentence for Jared Gillum, beginning with Amber Norris on behalf of the state.
Thank you, Your Honor. Regarding count 1, making a false information, ask the court assign defendant to 13 months in the Department of Corrections. He would be able to earn up to 20% good time credit and would be subject to 12 months post-release. As previously noted, there is a special rule, so this case would have to run consecutive to a 2019 Sedgwick County case, which, as previously noted, we believe is flattened. 12 months post-release. He has no jail time credit. Ask court assess the cost of the action to the defendant. Regarding count 2, Your Honor, it is a Class A misdemeanor. Ask the court assign defendant to 6 months in the county jail concurrent. Mr. Favre is appointed, so the court will need to address court-appointed attorney's fees and the bid's application fee. There is no request for restitution, and based on defendant's incarceration, it looks like he has been in for a little over a year, or I'm sorry, no, he came in March of 2025. Your Honor, state's not requesting a fine. Otherwise, Your Honor, I don't think I have any further recommendations for the court at this time.
Very well. Mr. Favre, your formal recommendations regarding an appropriate sentence?
Thank you, Judge. We are asking the court to impose the discretionary portion of that special rule as previously noted. and to impose and grant the motion for a durational departure and order Mr. Gillum to do 13 months in the Department of Corrections. As noted in the PSI, that will need to run consecutive to a Sedgwick County case, as is noted on the face sheet. That case is expired. The case he's currently on is much older. We are asking the court to consider waiving Mr. Gillum's attorney's fees. We have no objection to the standard costs listed in the PSI, and that's the end of our recommendations.
All right. Thank you, Mr. Favre. And how much are your fees in the representation of this client?
$1,100, Your Honor.
Okay. Thank you. Mr. Gillum, at this time, I'm going to address you personally and ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court.
Yes, sir. I'm sorry. I'm just trying to catch up. I'm a little lost on maybe the wording, I guess. I thought I was getting a concurrent sentence, not a consecutive sentence.
Oh, the court hasn't imposed sentence yet.
Well, I know.
It's a decision that I need to make.
Everybody's saying that they're asking to invoke a consecutive sentence to what I'm serving. And
On Mr. Gillum, on Sedgwick County 19 CR 3447, which is a case that you've apparently already flattened.
What is that? I don't know what that means. I'm sorry.
Well, what they're saying is that this case would run consecutive to that Sedgwick County case, not the one that you're serving right now.
Okay.
In that case, that you've already done all your time on that case, Jared. We already talked about that.
But I don't know when that case flattened or expired.
So if I was to receive the court's recommendation of 13 months, it would start today, right?
Yes.
Okay. That's all I was trying to clarify. I'm sorry. But I just want to say that I do apologize for what I did in Butler County, making false information and the theft. I do want to apologize to the court and to the county, Butler County. I made a mistake a few years back. I'm paying for it now. I just request that the court that you follow the recommendations of my attorney, please. And like I said, I'm in a few programs. I'm in Conscious Initiative. I got a mentor. I'm in substance abuse program here. I'm in the Pathways Church program. I'm in the mentorship. I'm in about 4 or 5 programs here, trying to just better myself while I'm in here. So,
Mr. Gillum, with the programs that you're on, are you expecting to earn your good time credits?
yeah. So I'm eligible for 176 days of good time and 4 months of program credits. So once I complete my programs, I'll be eligible for 4 months reduced off of my sentence.
And so you think you might have a release date on this other case in April of 2026?
Yes, sir.
Okay. Well, congratulations on working hard in prison to try to improve yourself, Mr. Gillum.
Thank you. I appreciate it.
All right. Anything else you want to say to the court, Mr. Gillum?
No, sir. I just appreciate you guys' time, and I apologize.
This court has considered what's been presented before the court announces a sentence. Perhaps some remarks are appropriate. It is almost impossible for this court not to notice the extensive criminal record of this defendant. Crime after crime after crime of property crimes committed primarily in Sedgwick County, but other jurisdictions have been involved as well. And unfortunately, Mr. Gillum showed bad judgment, which I think he would clearly recognize in having yet another case, and this one in Butler County. It seems to this court incongruous with the interest of justice to set up a sentence where Mr. Gillum would not be facing any actual service of time for this Butler County crime. And the court has considered everything that's been presented in this case, but the court is taking into account that I believe Mr. Gillum is on a path to earn good time credits. This court presupposes that Mr. Gillum is going to earn his 20% of good time credit, not just on his prior sentence, but on any sentence that this court might impose. And the court's also taken that into account. The court will pronounce sentence in the case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of making false information, a severity level 8, non-drug, non-person felony, in which the defendant has a criminal history score of C, thus placing him in grid box 8C. The court hereby sentences the defendant to a departure sentence of 15 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed on that count. The court does find, to support its departure sentence in this case, that there was an agreed upon recommendation in this case for a departure sentence. The court has been impressed with the statements that have been made about Mr. Gillum's efforts in the correctional facility to improve himself. And the court does believe that a lesser than the mitigated sentence is appropriate in this case. However, the court has not departed as far down as the attorney suggested in this case. The math that I'm doing, Mr. Gillum, is this. This court has imposed a 15-month sentence. You could earn up to 3 months of good time credit against this sentence. This court is going to run this consecutively to Sedgwick County case number 2019 CR 3447. But the current sentence in Sedgwick County, the court's going, that apparently he's actually serving, the court is going to run this case concurrently with it. Now, Mr. Gillum, you explained earlier that you expect to have a release date on your other case in April of 2026.
Yes, sir.
If you earn your good time credits in this case, you would be eligible for release in about June of 2026. It's not going to be much of an extension of time if you earn your good time credits, Mr. Gillum, but I believe that there needs to be an addition to your prison sentence for what you did in Butler County, even if it just seems like a few weeks.
I understand.
Nevertheless, there will be a penalty component to this sentence, despite the fact that I'm running it concurrently. Again, it would appear to this court, if you earn your good time credits, you're out on this one in June of 2026.
All right.
On the misdemeanor case, misdemeanor count 2, for the offense of Class A misdemeanor theft, the court imposes 6 months in the Butler County Jail and runs that time concurrently with the time imposed on the primary count. No fine is imposed on that count. The only assessment this court will make to Mr. Gillum at this juncture is the court will be assessing a felony docket fee. I think that's $193. Mr. Gillum has a long period of incarceration behind him and in front of him. He doesn't have the financial resources to pay back bids amounts, despite Mr. Favre's valuable services. And the court will waive a bids assessment fee being charged and the attorney fees. Those will be waived in the case. When you get out, I'd rather have you spending your money, Mr. Gillum, on taking care of yourself.
Thank you. I appreciate that, Your Honor.
And I'm sure you've got some other court costs on other cases you still need to get taken care of.
Yes, sir.
All right. It does not appear, due to his prison incarceration, that jail time credit is appropriate in this case. Face sheets 0 suggestion is adopted by the court. There does not appear to be a request for restitution. Some point in the future, Mr. Gillum, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. I do want to make sure that the record is clear here that the court has already dealt with the issues of consecutive and concurrent sentencing. This court is invoking the special rule in this case to order a prison sentence in this case. It was contemplated by the joint recommendation, and the court adopts that. The court does find that it's appropriate to impose the special rule and actually order a prison sentence to be served by this defendant. Under certain limited circumstances, Mr. Gillum, criminal defendants have a right to appeal to an appellate court having jurisdiction, and if you are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal, and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, I think I've covered all aspects of sentencing in the case. Are you aware of anything further that needs to be addressed?
No, Your Honor, thank you.
Mr. Favre, are you aware of anything further?
No, Your Honor. Thank you.
Mr. Gillum, we've covered a lot of ground this morning. Do you understand the court sentence?
Yes, sir.
I impose this sentence today with a confidence in you, a confidence that you're going to earn all of your good time credits. And about a year from now, you're going to be out on the streets. And I hope that you can just carry what you've learned in prison and how you've developed in prison, and then can just make sure that there's no further additions to your criminal history in the future. Good luck in that
Yes, sir.
regard, Mr. Gillum. I hope you make it.
Thank you. I appreciate you, Your Honor.
All right. Court will keep the custody of the defendant, remand his custody to the Secretary of Corrections to serve the 15-month sentence that's been imposed here today.